the Oversight Commission. We'll start now, and our first order of business, and you got to remember we haven't met in about 6 or 7 years, will be the election of new officers. Okay, so are there any nominations? I have one. If there's not, I would nominate to be the new chair would be Senator Surville.
I second that.
Okay, are there other nominations? Well, going once, going twice. Nominations are closed, and all in favor?
Aye.
Aye. All right, Scott, it's yours.
Thank you, Senator Sazla. We have to elect a vice chair also. You can stay where you are. That's fine. We need to elect a vice chair. Are there any nominations for vice chair?
Nominate Delegate Kilgore as vice chair.
Actually,
I'll second that.
okay. Are there any other nominations for vice chair? Okay, all those in favor of Delegate Kilgore as the vice chair, say aye.
Aye.
Anybody opposed? No. Great. So we have a chair and a vice chair. Okay. No, I'm good. You stay right there. Hobie, probably a good idea if we take roll, right?
We can do that.
Figure out if we have a quorum. Okay.
Senator Saslow.
Here.
Senator Lucas.
Here.
Senator Surville.
Here.
Senator Obenshain. Here. Delegate Kilgore. Delegate O'Quinn. Here. Delegate Sullivan. Here. Delegate Scott. Here. Delegate Runyon. Here. Delegate Webert. Cassidy Rasnick.
Here.
And Meade Browder.
Here.
Mr. Chair, you have a quorum.
Great. Thanks, Hobie. Well, again, I want to welcome everybody to the first meeting in 7 years of the Commission on Utility Regulation. Hopefully, we're going to meet more frequently than the cicada cycle. But the code, I think, requires us to meet once every 2 years now, and I think it'll probably be more than that once we get going here. But I'm really excited. We're going to get some staff here soon and start doing some interesting policy matters. And we have an agenda in front of us. Next thing on the agenda is adoption of electronic meeting policy, which I thought was important to look at to help facilitate our meetings, especially if we're going to be meeting more frequently. Tom prepared a draft policy for electronic meetings, and the way he drafted it was to basically allow the maximum flexibility possible under the electronic meetings statute that we passed. And I guess in order to put this in proper form before us, amendable or otherwise, I guess I would ask for a motion to adopt the policy that Tom drafted. Is there a motion?
I'll move it.
Is there a second? Okay, it's been moved and seconded. Is there any discussion about this policy? I know this is more extensive than we do on some other commissions. Anyone? Tom, you want to explain the policy?
Thank you, Mr. Chair. Under 2.2, 3708.3, there are both individual members and how they may participate remotely as well as an all-virtual meeting. The full extent under that code section for an individual member to participate electronically, they may do so because the member has a temporary or permanent disability or other medical condition that prevents them from attending, or 2, they are taking care of a family member who has such a temporary or permanent disability, or 3, the member's principal residence is more than 60 miles from the meeting location, or 4, the member is unable to attend due to a personal matter. When individual participation is due to a personal matter, the participation is limited to 2 meetings per year, or 25% of the meetings held that calendar year, and the member must give the personal matter reason with specificity. The entire body may meet virtually under that code section up to twice a year, or 25% of the meetings, whichever is greater. They cannot be held back. All virtual meeting cannot be held consecutively with another one. And members may participate fully, including voting in those all virtual meetings. I do understand that some other commissions have pared down that policy somewhat, and that will be up to you all if you wish to do that.
Thanks, Tom. And just reflecting a minute, it just occurred to me, we made another faux pas in starting this meeting. Nobody got a chance to introduce themselves, so I think we probably ought to do that really quick. So why don't we start, with Delegate Scott down there? Introduce yourself. We already did. No, we haven't voted on it yet.
So we didn't. Anyway, your meeting, Mr. Chair. Don Scott from Portsmouth, Virginia, House District 80, soon to be House District 88.
Rip Sullivan, currently the 48th District, hopefully the 6th District next time around.
L. Louise Lucas, currently the 18th Senatorial District and the newly drawn 18th Senatorial District.
Dick Saslaw, 35th Senate District, but not for long.
I'm Scott Survell, 36th Senate District, hopefully the 34th in a couple months.
Mark Obenchain, Senator from the Shenandoah Valley.
Delegate Chris Runyon from Augusta, Rockingham, and soon to be Highland and Bath.
Israel O'Quinn, I'm from Bristol, Virginia, represent the 5th House District, soon to be the 44th.
Mike, why don't you go?
Delegate Michael Weber, currently the 18th House District, soon to be the 61st.
Meade Browder, representing the Attorney General's office.
I'm Cass Rasnick. I'm representing the economic development community.
Great, and just everybody knows we have 2 vacancies on the commission still. One is a representative from the House of Delegates appointed by the Speaker, a civilian, and the other one is a governor's representative, and I think they have specific subject matters they're supposed to represent. But anyways, we're waiting for 2 more people. So back to the policy. So we have the policy in front of us. Tom's explained it. It's a little broader than the policy that I think other commissions have adopted. Does anybody have any comments or suggestions or amendments? No?
Did we talk about removing the virtual participation?
Yeah, we talked about potentially conforming it to the policy of the Joint Commission on Healthcare. And does anybody want to make that motion?
I will so move.
Is there a second? Second. Okay, is there any discussion on that? Tom, can you explain what that means?
Yes, sir. The Joint Commission on Health Care adopted an electronic meeting policy that was similar to the one that I drafted it, but it had a few exceptions for individual participation. It removed the ability to participate because the member's principal residence is more than 60 miles from the meeting location. It also restricted a member who is participating individually cannot make motions or vote. And then for an all virtual meeting, then the policy would say that it is the policy of the commission not to hold votes during all virtual public meetings.
Okay, is there any other discussion? Anybody want to speak up for Delegate Kilgore? No? Okay.
I think all of us are 60 miles away.
Yeah, we probably are, you're right. Okay, okay, well, having no further discussion, all those in favor of adopting the amendment, say aye. Aye. Anybody opposed? Okay, now we have the full policy in front of us. Is there a motion to adopt right, yeah, okay. It's been moved and seconded. Any further discussion? Okay, all those in favor of adopting the policy as amended, say aye. Aye. Anybody opposed? Great. Hobie, can you show all those are unanimous votes? Great. Okay, so folks, next we have on the agenda is to go over the commission. We had some legislative changes that went through due to legislation that was passed by myself and Delegate Kilgore, and I think we have a PowerPoint that, who's going to give that? Amigo or Tom, you're going to give it? Okay, great.
Just a quick overview on the commission. It was established in 2008 as a continuation of the Commission on Electric Utility Restructuring, which was established in 2003 to work with the phase-in of retail competition in Virginia. With a re-regulation in 2008, the commission was renamed and reestablished as the Commission on Electric Utility Regulation with the purpose of monitoring the SEC's implementation of the Virginia Electric Utility Regulation Act. Not sure what's going on with the monitor. Powers and duties of the commission are to monitor the implementation of the Virginia Electric Utility Regulation Act, to examine reliability concerns relating to electric generation, transmission, and distribution systems, establish one or more subcommittees as necessary, monitor applications by the Commonwealth for federal grants and awards for energy projects, to consider legislation referred to it during the General Assembly session, conduct studies and gather information, issue ratepayer impact statements for electric utility regulation. I'll go into a little more detail on that later. And finally, to issue an annual report to the General Assembly and the governor. As Senator Shervill alluded to, Delegate Kilgore and Senator Shervill each had identical bills, which expanded the powers of the commission. First, it extended the sunset from July 1, 2024 to July 1, 2029. It added 3 non-legislative members as well as a representative from the Attorney General's office. It requires the commission to meet at least twice annually and to elect its chair and vice chair annually. It also requires an annual report from the SEC regarding the implementation of the Electric Utility Regulation Act. It requires members to receive an annual orientation on electric utility regulation from the SEC. The SEC's presentation later in this meeting will satisfy that requirement. It requires, it authorizes the commission to employ an executive director and other staff. And Amiga is going to get more into that later on. It requires the commission to prepare ratepayer impact statements, requires each investor-owned public utility to submit its annual report disclosing efforts to conserve energy, requires the Department of Energy to present its Virginia energy plan to the commission at a public meeting. Ratepayer impact statements. A ratepayer impact statement is a statement prepared using data or other relevant information to estimate the potential impact of proposed legislation on ratepayers' electric bills. These are prepared by the commission upon request by the chair of the House Committee on Commerce and Energy or the Senate Committee on Commerce and Labor. Each chair may request up to 5 ratepayer impact statements during any given session of the General Assembly. And at its discretion, the commission may prepare more upon request of any member of the General Assembly. There are various reports in code that are required to be given to the commission. As I mentioned earlier, SEC is required to report annually on the implementation of the Electric Utility Regulation Act. The SEC is required to report annually its assessment of the practices and policies of the regional transmission entity. The SEC is required to provide periodic updates to the commission on the implementation and operation of its electric energy consumer education program. The SEC is required to submit copies to the commission of its annual report assessing new generating facilities utilizing energy derived from sunlight and from wind, as well as submit copies to the commission of its annual report assessing the reliability of electrical transmission or distribution systems, integration of utility or customer-owned renewable electric generation resources, the level of investment in generation, transmission, or distribution of electricity, the need for additional generation, and distribution system hardening projects. Additionally, the Department of Energy is required to, prior to completion of the Virginia Energy Plan, present drafts of the plan to the commission and consult with the commission on the plan. The Department of Energy is then required to present its finalized energy plan to the commission at a public meeting. Also, each investor-owned electric utility is required to submit its annual report disclosing efforts to conserve energy to the commission, and each electric utility is required to provide a copy of its integrated resource plan. And that is the review of the commission, Mr. Chair.
Great. Thanks, Tom. Doesn't sound like we have a lot to do. But I hope everybody's ready to do some work because there's a lot of stuff listed there. I've been attending some of these NCSL meetings about energy supply, and the United States is about to spend trillions of dollars rebuilding its entire energy grid over the next 20 years, and hopefully we can help provide some thoughtful input as we all work towards that objective, which is, I think, why Delegate Kilgore and I thought we needed to resuscitate this this commission. So does anybody have any questions for Tom about any of that? None? Great. So next we have on the agenda a preliminary discussion about hiring an executive director. Amigo is teed up to talk to us about how we're able to do that.
Yeah, you can go in. Thank you, Mr. Chairman. I have just a short handout that has a couple of points. I think that it's important. What it is basically a couple of case studies with two commissions that we have, that DLS has stood up, I guess is the technical phrase, that were formerly staffed by Legislative Services. So just in terms of, I think I've seen what's in the budget amendment that you all will be looking at tomorrow. I hope you look at it very quickly. And but there are 6 positions, but there are also I think it's $345,525. That's for a partial year. I want to just, talk briefly before I got into the actual meat of it, just some initial queries that you all may want to ask yourselves. The number of positions, that you have 6 now. The types of positions. You have an executive director. I think that in the initial budget amendment, there was one attorney and then some policy analysts. So that's going to be a part of what you all are going to have to figure out in terms of how you want it staffed. Then you have to look at office space as well as administrative costs, everything from purchasing computers and things of that nature. So, and I also would suggest that you think about putting together a hiring committee of 3 to 5 people. I think that's what the Behavior Health Commission did. So I have a couple of case studies that I'm going to go through with you just so you have an idea of what you'll be looking at. So the first one deals with the Behavior Commission. The Behavior Health Commission. So basically, you have to develop a job description and a job advertisement, job posting, collecting applications and giving them to the hiring panel, scheduling interviews, developing an offer letter, and onboarding the executive director. Those are things that Legislative Services that my HR person will help put together for you. I think we can certainly, working with the hiring committee, get real specific about that. Once the executive director is hired, that individual, he or she would take over the remaining stand-up process with Legislative Services providing fiscal and HR support. That would include the hiring of the other employees, the creation of job descriptions, and anything that has to do with, staff management functions. At that point, we go to just providing HR assistance and fiscal assistance in terms of purchasing. That person will also secure office space, purchase office equipment, and administer the commission's budget and manage staff. The second case study wanted to give you an idea of what the fiscal breakdown would be, and this has to do with the Virginia Housing Commission. That commission was taken from under Legislative Services last year, and what I'm showing you is what the breakdown based on assumptions. The assumption was that there would be an executive director at that salary level, a legislative analyst, and a wage position. That came to $345,000. Then there was a total of about $51,000 and some change that was devoted to rent and administrative costs, which include office supplies. So basically, once you all put in place some sort of a hiring committee, me and Tom and my HR person Claire, we will work to get the job posted and take in all of the numerous applications that are going to come in, and then provide whatever support and assistance you all are going to need as you go through that process. Any questions?
So, Amigo, we were appropriated, assuming the budget passes tomorrow and gets signed, with $345,000?
$345,525, and I know that's for a partial year. It's not for the
right.
full
So by
year.
my math, if I assume that's for 3/4 of a year, that comes out to about $460,000 per year, which, looking at this budget, I'm not sure they would even cover 2 people plus expenses, right?
Right.
Even though we were authorized 6, I think, right?
Looking at my calculations, it's about 2.5 people. Because basically what you do is you look at the salary range that you want, and our practice is to multiply that by 42%, because that would cover the benefits package and the health insurance.
Got it. So we're authorized 6, but got money for 2, basically.
Right.
Yeah, okay.
Mr. Chairman,
It's Delegate Sullivan.
question.
Go ahead.
Thank you. I mean, I notice a cost for rent, which makes sense unless we can use Commonwealth-owned space. Is there some reason we can't use Commonwealth-owned space?
Well, even if it's Commonwealth-owned space, DGS.
They charge us?
Yeah, they have a charge. And I think that what I have there was what was included as the best-case scenario, the lowest cost. But yeah, there's still some rent that is involved.
Okay. Thank you, Mr. Chairman.
Does anybody else have any questions for Amigo about his analysis? So Amigo, the one-time expenses, the one-time stand-up costs, any estimate of what that usually is? The one-time stuff.
Yeah, there really won't be any one-time costs because my staff will be doing those things, paying for the job advertisements and those things. Once the one-time cost, we don't really factor that in. That's something that we take care of.
And remind me again, what are the administrative expenses that are shown here?
The administrative expenses would cover, they would cover things like office supplies, computers, office furniture, and things of that nature.
Does that cover like conference travel or things like that, or just?
That would be a part of what would be included, yes.
Okay.
So I'm just thinking that, as you go into the next budget cycle, that those are things that you can think about just in terms of making sure that you have all those things covered. And I can certainly help. My staff can certainly help, and I think Money Committee staff can certainly help too.
Got it. Well, all right, folks. So we have this a process in front of us here. Obviously, we're going to need some more money. We got some people, I think, up here that can help with that next year. Knock on wood. These people are going to get thrown into the thick of it if people start requesting ratepayer impact statements this session. I think 5 per chairman or something like that. These people are going to be busy. So we need to come up with a committee, I guess, to try to hire an executive director to start working on this. It seems to me we ought to have one person from each side, each chamber, and then you said, have we done this before? That's typically we do, plus a civilian?
Yeah, yes. Typically, if you look at I'm looking at the pandemic study, there were 2 senators, 2 delegates, and 1 of the citizen members.
Right. So who wants to help me and Delegate Kilgore?
Mr. Chair, I think I might be the only person that qualifies.
Yeah, I think you might be the only civilian. Okay, so I got Oben Shane over here has volunteered, and Don, did you say you want to go to RIP? You guys want to figure it out? Rip can have it. Okay, Rip can have it. Okay. So I guess we have a proposed hiring committee of Servell, Oben Shane, Kilgore, Sullivan, and Rasnick. Is there a motion to that effect?
Second.
Okay. So moved and seconded, that be our hiring subcommittee. All those in favor say aye.
Aye.
Anybody opposed? Great, so I guess we'll have to have a in-person, potentially semi-remote meeting of that.
Mr. Chair, question. Yeah. I guess I missed it, and I guess I missed it in the legislation. I don't see it outlined. What's the timeline to get this up and running?
My timeline is as soon as possible, yeah.
We got deadlines, we're gonna have action items, or is that the committee's job now to figure that out? I think you would at a minimum have a deadline for ED to be hired, at least even if it's interim.
Well, we need somebody in place as soon as possible to start setting this up and getting it organized. So I would hope we could have a meeting very quickly to figure out how we can get this position advertised so we can have a pool of people to interview and make a decision on. So my guess, it'd be hard to get that done in less than a month, I would think.
Yeah, I mean, at least 4 to 6 weeks.
Yeah.
Just in terms of how long you want to advertise the position.
Right. Senator Lucas, I see your speak light's on. You have something you wanted to say? No?
Yeah,
Okay. Senator Lucas is volunteering for nothing. Okay. Okay. Is there any, I mean, obviously, we're going to need to have somebody, a really good executive director. The advice I've been given about this is put a lot of time and thought into who your ED is going to be and make sure you have somebody who's really good at it and somebody everybody trusts. So that's, I think, going to be critical to a good functioning commission here.
I'll work very fast to get something back to the hiring committee that will put together a timeline. But I also know that I've instructed all staff that I will match any offer that the commission makes. So don't look our way.
Is that in the budget day? No? All right. Okay, so we have any other thoughts or questions or points about the executive director process? No? All right, we're moving along. Okay, great. Thank you, amigo. Next on the agenda is the orientation that we're required to undergo every year by the State Corporation Commission to teach us how to regulate utilities. So who's here from the SCC to present? Oh, come on up, guys. Yeah. I guess for those of you who are on the House Commerce and Energy Committee, or Energy and Commerce Committee, you guys just had this same thing, I think, but we haven't had it in the Senate yet, so sorry. So, Mr. Bolstad.
Yes, Mr. Chairman, good afternoon. Members of the commission, good afternoon. With me today are Kim Pate. She's the Director of Utility Accounting and Finance. And following my very brief presentation on the commission's authority, she's going to talk about rate making and the impact of the 2023 legislation on that piece of it. David Essa, right there, is the Director of Public Utility Regulation, and he's going to talk about applications to the commission for the approval of facilities such as transmission lines and generation facilities. And he's also going to talk very briefly about reports that you all get, some of which Tom has also mentioned from the commission. So that's our tasking for today. Very briefly, and so many of you already know the work of the commission and where we come from, so I'll just make it very compact. The commission is a permanent commission established under the Constitution. Let's see if we can get to slide 1, maybe not. Okay. You know, I'm just going to talk through this, and if it comes up, it comes up.
Maybe
Okay.
Google Translate will read that.
Right. Now, you all, that's right. You all have been given copies of the presentation, I believe, in your chairs. So even if you can't see it up on the screen, there it is. Okay, great. So Article 9 of the Virginia Constitution, it makes great reading, but anyway, it's our authority, Commission's authority to function. The Commission is given duties to regulate the rates, charges, and services for various utilities, including electric companies, which of course is your tasking here. And the SEC has other powers and duties as may be prescribed by law, and there are a number of unusual ones, including the regulation of a certain toll road and also establishing pilotage rates. In fact, we have a pilot case in front of us now. The code provisions that implement the constitutional provisions are in Title 12.1, and that describes the powers and duties in more details, such as commission process, subordinate employees, appeals, and so forth. And unlike some other agencies here in state government, appeals from the commission's decisions go directly to the Supreme Court. So that's an interesting piece of the puzzle. The commission has other responsibilities other than utilities, such as financial divisions, the Bureau of Insurance, Bureau of Financial Institutions, Division of Securities. And in addition to the utilities on the electric side, the commission also regulates rates and services for gas utilities and certain investor-owned water and wastewater utilities. So there are usually a lot of bills that come before members of this body and jurisdictional committees during the year involving utilities, and those generally amend provisions currently in Chapter 23, which basically got put into the code starting in 2007 in a serious way to establish hybrid utility rate making and provisions for investor-owned utilities that were established in that 2007 legislation. Chapter 10 remains the traditional rate making provision for certain utilities such as electric cooperatives, to a certain degree, gas companies and water utilities. So that's kind of it in a nutshell. The commission usually is in contact with the committees during the session. We appear before you. We talk about legislation that's been introduced, and to the extent that you have questions, we answer your questions. If you have any questions today, we'll obviously answer questions, and we're looking forward to working with you all as a commission, either individually or members of this commission or in jurisdictional committees in the upcoming 2024 session. So that's all I have, and I will now just turn it over to Kim Pate to talk about rate making and some of the things that happened during the 2023 session that affect rate making for jurisdictional utilities here in the Commonwealth. Kim?
Can we get the slides back again? Good afternoon. How are y'all doing? I know y'all like talking about utility rate making, so glad y'all are joining us for this today. And just a reminder, again, the SCC is an economic regulator, which again means we're going to set the rates and tariffs. We're looking at that side of it, quality of service, but that is our task. And just another reminder once again that the main thing that we're looking at is what is the cost that the utility incurs to provide service to customers. And customers provide all reasonable and prudent cost of providing that service. So whether that's a capital expenditure, whether it's salaries, whether it's financing costs, both the interest and the debt component, those are costs that are recovered from customers. And those costs can be reduced also if the utility is able to get any grant money or any low interest loans. So that can be a reduction to customer cost. Let's see. Oh, there we go. We have 3 different types of electric rate proceedings. The first one we have identified is the fuel factor. That is, it's the original rate adjustment clause that we had. We talk about RACs all the time. The fuel factor was the original RAC. It's a dollar-for-dollar recovery mechanism for all the fuel costs. There's no profit or loss component to it. Whatever the utility spends on fuel, whether it's coal or natural gas or whatever the component is, they recover dollar for dollar. The second component, this was new back in 2007, are the rate adjustment clauses. So again, they are dollar-for-dollar mechanisms for a specific cost. Now, those can contain a profit component to those, which differs from the fuel factor. And currently, Dominion has about, I believe, 21 rate adjustment clauses, 22 including the fuel factor, and APCO probably has about 8 or 9, and we'll see that in a few minutes. And then finally, we have base rates. And base rates recover all the rest of the cost. If it's not through a RAC, it's recovered through base rates. And we'll talk about the recovery mechanisms on that in just a second, too. So we just wanted to kind of identify the rate application process. It's a long process. We have it covered on 2 slides, and I'm not going to go through all of it. But the important thing to know is it is a long process. It usually starts when the utility files an application for a rate increase or a rate decrease with the commission. That's usually the starting point. And there are going to be steps that go through it. But at the end of the day, a lot of parties can participate. We will have the Attorney General's office. We will have industrial customers. We'll have other consumer advocates that participate. They all have the opportunity to fully develop the record, whether through pre-filed written testimony, oral testimony. Those can all be provided. And this is information that the commission uses once they develop a full evidentiary record to make its determination. So it's a fact-based determination. So again, I'm not going to go through all of the steps, but at the end of the day, that's what we're getting to. And the time frame can vary. We have legislative time frames that can be very quick from the time the application comes in to the time the final order comes out. Most of them are about 8 or 9 months between when the application walks in the door. We have to go through this whole process, and the commission issues a final order. That's kind of the typical time frame. So I'm going to move ahead. Let's see. The next 2 slides, we always seem to present these. They just give you kind of a snapshot in time of the rates of both Dominion and Appalachian Power Company. The first one is Dominion, and this is the rates as of September 1st. So this is very new. There were multiple RACs, rate adjustment clauses, that went into effect on September 1st. So if you look in that first column, you'll see the current residential rate, and you'll see that their base rates, the fuel factor, and it then lists all the other different rate adjustment clauses. So in total, there are about 22 of them there. And if you look on the bottom line, you'll see total and the current bill, and this is for a typical residential customer that's using 1,000 kWh, is about $134. The next column shows some proposed increases and/or decreases, depending on which way they're going. And then the last column shows those potential effective dates. But that's when the commission will have issued an order and we'll actually know when those rates are. So then if you turn to the next one, the next slide, you'll see Appalachian Power's. And it's the same information. Again, it starts off with the base rates, and you'll see the different rate adjustment clauses that Appalachian Power Company has. And that column labeled current residential bill, again, based on 1,000 kWh, their bill is currently just under $162 per month. In the next column, you will see any proposed and pending increases and what the proposed bill would be. And you can see in the far right column what the rate effective date is. Okay. So now we thought we would just bring up some of the what regulation is like today after July 1 of 2023. Again, we're back with the electric utilities, back to biennial reviews. So every other year. Dominion's in the odd years, APCO's on the even years. Currently this year we have had both APCO and Dominion in, one in a triennial review, one in a biennial review. But the biennial reviews will start next year with APCO, which will actually be a one-year review of their rates, historic rather than two, just to get on track. And then Dominion will be in 2025. And they'll go every other year from there. As a result of a biennial review, customers could see a refund if their historic earnings are showing that there was money to refund. And then also the base rates can change as a result of the biennial review. Base rates changing meaning they can go either up or down. They could go either direction. So just depends on what their financial need is compared to what their current rates are producing. And let's see, I have several different things. Another interesting item to point out is that with the return on equity, that the commission can use any reasonable method to develop the return on equity. This isn't going forward after the current 2023 biennial review. One of the new provisions provided in the code as of July 1st was for securitization of a period cost. And we currently have an application by Dominion in pending before the commission to securitize its under recovery balance for their fuel costs as of June 30th, 2023. So that is a pending proceeding. At this point in time, Appalachian Power Company has not filed to use that new code provision. Some more provisions in HB 1770, SB 1265. For Dominion, it does set rates for 2 12-month periods. So you have a biennial review, so every other year you come in. Rates can actually be established for the first year after the review and also the second year, so they can change during that period of time. That is a change from how we were regulated pre-July 1st. Also in July, Dominion incorporated about $350 million worth of rate adjustment clauses. They stopped charging those, and so they're effectively that cost is being recovered through base rates now. So they're no longer charging racks for that $350 million. That had for a typical customer, it reduced their bill about $7 to $8. And there's some more provisions concerning, we refer to them as A8 provision costs. They're on here, but they're a little bit more in the weeds, so I'm going to, unless anybody has any questions later on, skip on over those for right now. And we'll go to the next slide and talk about the new provisions in A9, that's 56585.1A9. And again, in the 2023 biennial review for Dominion, there's still a collar, an earnings collar when we look at the historic earnings, but then the sharing mechanism, in case they are earning above that collar, has changed. It's now 85 to customers, 15% for shareholders. And that's only good, again, for this current biennial review. When we go to the 2025 biennial review, then we will go to there's no collar on the earnings test. And the sharing still remains 85-15, but you don't have that earnings collar that is either, too much or too little. It's just using the point. And then if you get above 150 basis points, or above the point, then 100% of that excess earnings goes to customers. So there's different provisions than what we had prior to July 1st. On the next slide, it talks about the return on equity And for the 2023 only biennial review for Dominion Energy Virginia, it's a 9.7% return on equity that was codified. So it says rates shall be set at 9.7% return on equity. So that's what we have for this biennial review. Again, once we hit next year with APCO's biennial review and then Dominion after that, the commission may use any methodology it determines to be reasonable to set the return on equity. Right. There are a couple other provisions on there that might be interesting later on. At this point, I'm just going to shift over to the APCO bills, the HB 1777, SB 1075, which again, they also had the provision, like I said just a second ago, for securitization that was added for APCO, but they have not taken advantage of that yet. As far as with APCO, they're again on a biennial review starting next year, but theirs will only look at setting rates for one of the 2-year periods. So rates can only change once in that 2 period of time. That's a little different from Dominion. In the past, it's always been just setting rates for a 12-month period. APCO is going to continue on with that. Dominion, again, has that ability to change the rates in the second of the 2 years. Using end-of-period capital structure, unless it's determined to be unreasonable. That's a provision that was in there prior to this also. I'm going to go over to the last slide on, sorry, I hit the wrong button. For the earnings test provision, again, the collar is for the earnings test is 100 basis points. And within that 100 basis points collar, earnings are neither excessive nor insufficient. But any amounts above the collar, customers will receive 100% of the refund on that. And again, there's still some of the, we refer to them as Section A8, 56585.1 A8 provisions, which have different costs. Have been identified for here on APCO, that still severe weather costs and natural disaster costs can be deferred. If they cause them to under-earn, they can be deferred to the top of the collar, which means they would not have to recognize those costs immediately, and they could amortize those over a future period of time and try to recover them that way. And I know that was very quick. There's a lot that goes on in the legislation, and I could spend multiple hours going through this, but fortunately, I'll turn it over to David, and he can talk about more important stuff.
I don't know about that. I think yours is just, or if not more important. Okay, so we will be shifting from strictly dollars and cents, which is what Kim has been talking about, to a different aspect of commission oversight of regulated utilities. If we can have the slides up, please. Okay, so shifting on to certificates of public convenience and necessity. This may be a term you may have heard in the past. They typically refer to it as CPCNs, okay? And this refers to certificates that the Commission grants to regulated utilities and merchant developers, private developers, who are seeking to construct and operate electric distribution, electric transmission, and generating facilities within the Commonwealth, okay? So these applications are initiated by the utilities or the developer that wishes to construct and operate these facilities. And they exist in 3 different areas. One of them is going to be for electric generation facilities, I mentioned transmission, but it also applies to natural gas facilities for construction of these facilities. And I will just mention in passing that there are certain exceptions, right, to having to apply for a certificate of public convenience and necessity from the Commission. Certain exceptions apply. Just briefly, by way of example, in the case of transmission facilities, if these happen to be at voltage levels of exactly 138 kilovolts, then the applicant has the option to either seek a CPCN from the Commission or go to a locality to request permits. So that's an alternate process that's available to the utilities. There are certain other exceptions also that I'll just briefly mention them. In the case of generating facilities, if it's 5 megawatts or less, then in those cases, the applicant can simply request or send a letter to the director of the Division of Public Utility Regulation, provide certain information, and then they can be granted that approval without having to formally request for a CPCN. And then again, there's the other option that you all may already be familiar with, that applicants can go to the DEQ for generating facilities that are sized up to 150 megawatts to seek the DEQ's permit by rule as another option in order to be able to construct and operate generating facilities. Go on to the next slide. Oh, no, actually, before I do that, I should also mention in terms of the commission proceeding that occurs in response to an applicant's filing, okay? The process is fairly similar to what Kim described for rate case applications, okay? Applicants submit the application, the commission issues an order for, could be for order for notice only or order for notice and hearing, okay? And this process provides an opportunity for the public to submit comments that become a part of the case record. There is an opportunity for folks to participate as respondents in the proceeding, okay, formal respondents. There's opportunity to file testimony in the case that gets filed in the docket. Then there is the evidentiary hearing, typically. Then there's the opportunity for the utility to submit rebuttals in response to testimony that has been filed. And then, of course, it culminates in the commission's issuance of the CPCN to either the regulated utility or the developer that is seeking the CPCN. So that's typically how this process plays out at the commission for these CPCN applications. Okay, next I will just show certain reports that we've been required to produce for the General Assembly to different group entities within the General Assembly and the cadence at which we file these reports. You have these energy efficiency programs that are annual reports, and then maybe of particular note, of particular importance to this commission is the CEUR report that we are required to file annually. And Mr. Stevens went through in some detail as far as what's needed to be included in those reports. So I will not repeat that information. I will just draw your attention to the link at the bottom of this slide that shows you where you can go to retrieve all the previous reports that have been filed in previous years. I will also mention that we are currently working on a report that should come your way by November 1st of this year. Okay. We have other reports that are every 5 years. We also have, those other 2 reports that you see after triennial review, and then the qualifying investment report. We have the American Rescue Plan Act. It's also another report that we typically send to you annually. And once again, I will not be going into detail unless anyone has specific questions related to these. Finally, I will just mention some recent reports that have come the way of the General Assembly, okay? And they have generally been in response to bills that were passed during the General Assembly sessions. In no particular order, you would have things like the life cycle of renewable energy facilities that we worked on. I think a number of you might be familiar with that. The report went out back in 2022. A much older report would be the data access and privacy stakeholder report. That goes all the way back to 2019. We have the Energy Storage Task Force report. That was back in 2020. We had the Transportation Electrification Stakeholder report. That was in 2021. We had the Shared Solar for APCO, Old Dominion, and Kentucky Utilities Stakeholder report, also back in 2022. We performed a staff letter study on utility disconnections back in 2022. And there's one other report we presented. I don't think it's on the slide here, but I'll just mention it in passing. That's, you might recall the SCC was tasked to come up with a program to encourage and expedite infrastructure investments by phase 1 or phase 2 utilities, essentially a site development program to expedite deployment of these projects. So the SCC established that program. We were also required to create a report to be submitted, which we also did by the due date, but that's not on your slide. I thought I should just mention that to you as one other recent report that we've worked on. So I am open to questions you might have at this point.
Great, thank you. I have a couple questions to kick things off, and either you can, this is probably for, I had a couple questions for Kim about what she presented. Kim, you mentioned grants and low-interest loans. I know
Yes.
one of the things that we're tasked with is trying to keep track of applications or making sure we're maximizing the use of federal dollars in the state. And I know there's at least like a $300 billion DOE energy loan program out there. There's other big federal grant opportunities under the Act. And I know a couple of utilities had mentioned to me that when federal dollars or low-interest subsidized loans come in, it gets taken account in the rate-making process differently than a private sector loan or a private or use of stockholder capital might be used. I mean, can you explain sort of how that differs so that we can understand that?
Yes, if it's cost-free or if it's low interest, it's going to reduce the cost to customers. So let's just, for example, say they got a $10 million grant. And that $10 million grant is to offset the cost of the capital investment. Then if the capital investment were $100 million and you got a $10 million grant, then the net investment that customers would pay for would be the $90 million because the utility was able to acquire the grant at no cost to them and just reduce the cost to customers. Now, there are different ways that grants and low-interest loans work, et cetera, but I think the important part is at the end of the day, if they're able to get that cost-free money or low-cost money, it helps reduce the cost to customers. It is passed on to them.
However, it also, though, would mean that the utility cannot earn a profit on the money on that $10 million that is used to purchase the capital asset, right?
If it's doing the capital asset, yes, that's correct.
Got it.
But that's because all right. So why do we earn a profit margin? That goes back into the time value of money. Generally, the utility builds a project. Again, $100 million project as an example. The company has to acquire the funds and put the money out front. Customers pay for it over the life of the asset. So as a result, to get a time value of money, to get money so that investors will buy Dominion stock, that's why you have that. If the company is able to attract capital that is cost-free, it doesn't cost them, they're able to get the money up front and reduce the cost up front, they really should be kind of indifferent on that.
Okay. I also had a question to you about the rate cases. You talked about the rate cases. I guess there's the APCO case, I believe, there currently is a pending settlement, right?
The settlement has been offered to the commission, yes, but it's a pending case, so we really can't discuss it any more than that.
I got it.
Unfortunately.
Got it. And the Dominion rate case has been filed.
Correct.
What kind of a time frame is there typically on a rate case? From like when does it start to when a decision is rendered? Typically, I don't know if there's
Well,
a
by
required-
statute, a biennial review is 8 months from start to finish. So usually, typically, they're always filed on March 31st, other than the current Dominion biennial review. So that's why I have to say generally. It's normally they file on March 31st, and an order is due by November 30th. Now, one legislative change is that for APCO going forward in their biennial reviews, the final order will be due by November 20th, rather than the normal 8 months. So just a few days earlier.
So when is a decision due in the Dominion rate case that's been filed?
Let's see, they filed July 1st.
April or May?
Yeah, like March. Does that give us 8 months?
Okay. Got it. Okay. And you had also a slide there, two other questions. One was you had a slide in there about return on equity.
Yes.
And we've had a lot of inflation lately. Inflation, where does that come out in the process? Obviously, it comes out in the base rates, but not necessarily the return on equity. Is that right?
Yeah. Inflation really hits everything, right? If the cost of the goods go up, the materials, the labor, any of that, it's going to be reflected in items that are recovered through base rates, and it's going to be reflected in items that are recovered through the racks. If it costs more to buy the natural gas, or a solar PPA costs more, then that's going to go through there. The labor that they have to pay for, whether it's through base rates or whether it's through a rack, that will be included for it. As far as return on equity, what we're looking at is a market return on equity. We're looking at financing costs for both the debt and the equity, and you're looking at more information concerning the market, not just, what's inflation today. That's just not one point that you
So
look
does
at.
that mean that because interest rates are up and borrowing rates are up, that's going to put pressure on return on equity? Is that what you're saying?
We have some testimony before the commission right now, dealing with all of that, and it's currently pending before the commission. So I'm going to look to Arlen. I'm probably not, I probably can't go into those details, but our staff testimony addresses that, if you want to look at the public record in the case, and we'll see what the commission determines at the end.
Okay. Okay, I had one last question, which I think you all just issued a decision on securitization, is that right?
No.
Or is it a recommendation?
The hearing starts tomorrow for the case.
Okay.
So scheduled for 3 days. But there's been testimony, pre-filed testimony filed by all the parties. The evidentiary in-person hearing starts tomorrow. There's a 4-month time frame for an order to come out from the date that it was filed. It was filed on July 3rd, the application was.
Got it. I'm not going to ask you about a pending case. Does anybody else have any questions? Delegate Sullivan.
Thank you, Mr. Chairman. Ms. Pate, also on ROE, I guess it's, yeah, in both slides for Dominion and APCO, you talk about the performance-based adjustments to ROE.
Yes.
Has the proceeding been started that's due on December 31st?
No, it has to be initiated prior to December 31st.
Okay.
And actually, the results of that cannot be built into the final review for 2025.
Right.
But it can be extended for good cause to 27. So this case will be initiated this year, but again, we won't see it until 25 in the biennial review, or potentially 27, the results of that.
So how long will that proceeding last?
The commission hasn't
You don't know?
established it yet. I do not know.
Okay. Thank you, Mr. Chairman.
Any other questions? I had one other one that occurred to me while I heard that. I didn't hear anybody talk about the role of the IRP in any of this. Can maybe somebody explain to us what the role of an integrated resource plan is in terms of us understanding how you do your job and how you make decisions?
Yeah, the IRP, I guess straight off the bat, one thing to make clear with the IRP is that projects that the utility is going to propose in the IRP eventually come to the commission through a CPC, and in most cases, assuming the utility would like to construct projects associated with it. But at the high level, the IRP is the utility's plan on how it's going to be meeting the load demand that it foresees over the foreseeable future, the resources that it plans to deploy to be able to meet those loads demands that it has. So certain things that come into play include like the load growth that it projects, and things like that, in addition to the different types of resources that is proposing to meet those demands. And they will typically have a number of different plans or different paths to achieve that objective of being able to meet that load demand over those number of years. So you typically hear of a plan A, a plan B, a plan C, and they have differences within those plans in terms of, for instance, whether they are proposing to deploy certain types of generation resources, maybe in response to legislation that has passed. All kinds of different assumptions get built and disclosed associated with each of those different plans that they would propose in that IRP proceeding. And once again, respondents in the case are, free to weigh in on their thoughts as far as what they think of the utilities' plans towards meeting those objectives.
So David, Mr. Essa, can you just explain to me, you all have to approve the IRP. It's something that's litigated, I guess.
Yes.
And you all approve it. What legal effect does an IRP have, or does it carry some weight in a future proceeding, or how is it used going forward? It's not clear to me why you have to approve it if it's just a plan or a guide.
Right. The commission has to determine that the different plan, usually the utility has what they call the preferred plan, if you will, right? Out of those different plan options I mentioned, plan A, plan B, plan C, and so on and so forth. It's the job of the commission to determine that the proposed plan, for instance, is reasonable and likely to achieve the goals that it sets before it. And the commission, as we often say, speaks through its order. So it can often make different, it can lay down different, it can direct that different changes be made to the IRP, for instance, okay? So it's up to the commission's discretion to impose conditions on the different plans that the utility might be proposing. So yes, it does carry weight. Oftentimes, the commission would make certain directives that it wishes to see in the subsequent year plans, and the utility is obligated to satisfy those directives contained in the final order. They do carry weight, the commission's order.
Got it. Anybody else have any questions? No other questions? We all oriented now? We all know what we're doing? Everyone? Okay, good. Thank you for orienting us, imparting your knowledge. We appreciate that. We're, I guess, ready to go. We've satisfied all our legal obligations. We have to do public comment next, and then we have one other item on the agenda after that really quick. So thank you, guys. So now is the part in the agenda here we do public comment. Is there anybody in the public that would like to comment on what we should do or ought to be doing now that we're meeting again? Nobody? Good. All right, Senator Saslow says good. Nope. So I just want to say to the members really quick that we need to talk about what we're going to try to accomplish in the limited time we have this year, and set an agenda to some extent for next year. Once we get an executive director, it'll be a little easier to do that. Delegate Kilgore and I had originally planned on getting a presentation from Dominion on their IRP that they just presented at this meeting, along with a presentation from the Virginia Department of Energy on what they had in process on grants right now. And we also were going to get a presentation from the U.S. Department of Energy on the programs they had available to the states for both private sector and the government entities. But Delegate Kilgore, after Tom Stevens reminded us of all the things that we had to do, decided we didn't want to keep you here for 4 hours. So we punted all that. So we do have those presentations. We have to get the IRP done sometime this year, that presentation from Dominion. And we can do those other policy presentations. We might do them remote or we might do them in person. But in any event, that's a couple things that at least Delegate Kilgore and I had talked about. But if anybody else has ideas that they would like to add to the agenda, I don't think we had any bills referred to us this year. Is that right, Tom? Right. Yeah, we had 4, I think, a couple of years ago, but I don't think we had any bills sent to us this year. So there's no bills in front of us. But we have if anybody has anything they would like us to vet or consider or look at, policy to consider for the next meeting besides hiring somebody, let us know. So anyways, I look forward to working with everybody. I think it's going to be a lot of fun, especially with some good policy staff to help us along. Is there a motion that we adjourn?
Mr. Chair.
Okay, I'm sorry. Is that Amigo?
That's me.
Oh, Don.
Can we, I know everybody's busy and it's a silly season. Can we try to at least lay out the date of the next meeting? I guess it's in December since we meet quarterly. So this is September, 3 months from now. We at least know we'll meet in December and maybe March, the end of each quarter. Can we get at least a date for the next meeting? Or at least, if not today, you could get something to us?
Yeah. Hobie, are you in charge of meeting dates now that, because I'm chair, is that? Huh? Yeah, so let's get a poll out. Does everybody want to aim for, what, beginning of December maybe?
First week of December.
Yeah, beginning of December. Does that look, yeah. Where did Amigo go? Is Amigo out there? Oh, he left? He said 4 to 6 weeks to hire somebody, which means, I guess the hiring committee, can the hiring committee hire somebody without? Yeah, does the commission have to approve the final hiring decision? Yeah. Yeah, so that's 6 weeks from now, which would be September. 8 weeks.
December.
Beginning of December? You want to hire somebody till then?
Best case scenario, you really think we're going to get a recommendation on the meeting?
That's a good point. Okay, first week is December. I think Obenshane's got some wise counsel over here. First week of December we're going to aim for. Okay?
Early December.
Early December. Okay, mark your calendars. We'll figure it out in the next week, and we'll get out a notice, and everybody can plan around it. Okay, is there a motion we adjourn? Is there a second? All those in favor say aye. Aye. Those opposed? We're adjourned.